Thank you. Welcome to this Licensing Act hearing. And the first order of business is to elect a chair, and I'll hand over to members.
I will nominate Councillor Baxter.
Councillor Patrick O'Leary. You second the proposal. Sorry, I was surprised you. Well, Chris, you reckon last time? Yeah.
Okay, all happy?
Yeah.
Lovely. Okay, so the chair is Councillor Ron Baxter.
Right. Yes, I'm Councillor Ron Baxter. Welcome. Good morning and welcome to this meeting of the Licensing Act panel. I'm Councillor Ron Baxter and I'm chair of the panel. Councillors Patrick O'Leary and Val Shaw are also joining me on the panel. I've a few statements to make before we proceed with the meeting. Please, can everyone ensure that all mobile telephones and any other devices are switched to silent during the meeting? In the event of a fire, the Democratic Services Officer will leave attendees outside the building where they should remain until directed to return. The meeting will resume once all attendees have returned to the meeting room and are ready to continue. If you have a question to ask in the meeting, you should raise your hand to alert me. Please do not speak unless invited to, and please do not interrupt other speakers. For those joining remotely, when you are not speaking, please ensure that your microphone is muted and that your camera is turned off. Are there any other questions on this at the moment?
Other than reception have told me we do have a fire alarm test at 11:30.
Good.
Yes, that's good to know. Do members of the panel have any declarations of interest to declare? No.
No.
The procedure for this meeting was included in the agenda pack. Could I ask if everyone has understood the procedure that will be followed, or does anyone have any questions to ask at this stage? There's an application for the review of a premises licence under the Licensing Act 2003 for Longlis 60 Vineyard, Abingdon. I'll now begin this item and invite the licensing officer to present their report.
Right, you've had a copy of my report sent to you in advance, which has gone out to all parties. So I don't propose to go through it in verbatim. I'll just go through to explain what each section is concerned. So what the licensing team are asking is for you, as you said, to consider the application for the review, and once you've heard all the submissions and taking into account the various acts and guidance and policy, to decide whether to modify the conditions of the premises licence, to exclude any of the licensable activities from the scope of the licence, to remove the designated premises supervisor. You can also have the power to suspend the licence for not exceeding 3 months, or to revoke it, or you may decide not to take any action at all. So on the 21st of July this year, an application for the review of the premises licence was submitted by Mr. Ian Wares, who is this gentleman here, who is a licensing officer, a civilian with the Thames Valley Police Force. And you have a copy of his review application in Appendix A. And obviously 3.4 summarises the points under which he makes the application for the review, and his conclusion in his application asks for the licence to be revoked. One of the items that he mentions, number 6, and I believe number 5 as well. It can explain more. I still believe there is an ongoing case into this. So when a review application is received, the licensing authority are required to put a notification to this effect outside the premises, and the applicant asking for the review, in this case Thames Valley Police, is required to send a copy of the review to all the responsible authorities and to the licence holder. Paragraph 3.6 refers to the licence that was in place at the time the review was received. You will notice that the licence is in the name of Mohammed Isra Nazir. Since the review was received, the licence has been transferred into a company name, which is Londis Marciano Limited. There is one director for this company. This is Mr. Mohammed Sarfraz Nazir, who is seated over there. Paragraph 3.8 refers to an incomplete application to change the designated premises supervisor, which all premise license need to sell alcohol. I'll just update that paragraph. And full application has been received to nominate Mr. Mohammed Sarfraz Nazir as the DPS. The Thames Valley Police have given notice that they believe that this change of DPS would undermine the crime prevention licensing objective. So this matter is currently due to be heard on Friday, the 3rd of October. But in the interim, in any case, Mr. Mohammed Sarfraz Nazir acts as the DPS until this matter is heard. So during the consultation period, which goes on for 4 weeks from when the representation was received from police, a representation has been received from a colleague of mine in the licensing team, Mr. Fletcher. That is included at Appendix B. That requests a revocation of the premises licence, and a representation has also been received from the Oxfordshire County Council Trading Standards team, which is attached at Appendix E. We have Mr. Simon Mitchell online, so you'll be able to ask him questions about his representation. So that also requests a revocation of the premises licence. So also, following the display of the notice, 19 representations were received from other customers of the shop, which are included at Appendix F. All those making representations have been sent a copy of the pack and invited here today, but we haven't heard back from anybody, or then haven't turned up here today. So moving on, section 4.1 refers to the relevant sections of the Council Statement of Licensing Policy. 4.2 refers to the relevant sections of the Secretary of State's guidance issued under section 182 of the Licensing Act. And of course I can, but there's got to be legitimate reasons how they sell it. And in this case, there's evidence that they haven't been going by the rules.
and the nitrous oxide's been sold to people that shouldn't really be getting it. The first point I got to raise on the Saturday, 22nd of June in 2024, local police officers were in the area. They saw a group of males near the shop who they weren't particularly happy about the way they were acting, so they went over. The stop resulted in a Section 23 drug search under the Misuse of Drugs Act 1971. During the search, there was canisters of nitrous oxide found on the male's possession. When asked where they got it from, they said they bought it from Londis. And it was clear that they were using it for misuse and inhalement. I say this is an offence under the misuse of drugs offence. Then in April, there was an incident reported to police where a 15-year-old female and her father had attended or called the police station saying that there'd been a serious sexual offence to the 15-year-old girl. On investigation, it was found out that this young lady had gone in to Londis on 5 separate occasions, and it says she was forced to buy alcohol and nitrous oxide. This is backed up by an email from the girl's father, who said that the transactions on the girl's cards, there's 5 payments made to that card, resulting in an amount of about £100. This was for alcohol and nitrous oxide. But on one of the occasions, the girl was so intoxicated that she fell coming out of the shop and had to be helped by her friends. They ended up in the park, and over the evening, a serious sexual offence, or alleged serious sexual offence, happened against the girl. CID has spoken to the detective who was dealing with the case, and while he was interviewing the girl and the suspect, they both admitted that they'd gone to Londis and purchased alcohol and nitrous oxide that night. And that is the concerns we've got. The fact that a young lady, underage person, has been sold alcohol and nitrous oxide, and she was very intoxicated. Some of the transactions. I say that is an offence under Section 141 of the Licence Act, selling alcohol to a drunk person, and also Section 146, selling alcohol to a person under 18. Obviously, with all the information that we've been getting from Trading Standards, Mr. Mitchell from Trading Standards, we decided to carry out a licensing visit at the premises. During the licence visit, which was carried out on the 2nd of May, we attended the venue. When we entered the shop, there was one person behind the counter. We spoke to the male, asked him a few questions about the licence, and it became quite apparent that this young man behind the counter had no licensing training. The only thing he seemed to know about was Challenge 25. When I asked him what that meant, he said, "We ask people if they think they're under 25. I asked him about training records. There was no evidence of training records. I looked at the CCTV, not at the footage, but looked at the monitor, because there's a monitor directly in front of the counter. And it did have the cameras in relevant places around the shop, which seems quite in order. Officers then, in fact, Mr. Mitchell then had a look around the store and found, I think, 61 or 64 large cylinders of nitrous oxide stored behind the counter, and also a couple of boxes upstairs. While we were doing this, the staff member was on the phone to Mr. Nazir, who finally attended the premises. During the search as well, we found quite a large, a 26-inch samurai type sword lying on the floor. When the officer asked what the sword was for, he said, "Oh, Mr. Nazir stated that it was only there for peace of mind." And that's been an incident a few years ago where I think he believed he got robbed, and he just has the sword there for peace of mind. Under the new Offensive Weapons Act, it's a prohibited weapon and shouldn't be in the shop at all. And the fact that he's saying it's there for peace of mind concerns me. That's if somebody did come in, what would happen? But I say that's an investigation that's been ongoing with the officers that were at the premises that night or evening. Also carrying out licensing visits. I noticed there wasn't the summary of license part B wasn't in prominent display. When asked where it was placed behind the counter on the top shelf to the left. When we got to see the license, a lot of the details had been covered by brown sticky tape. That's why it's not in prominent display. Mr. Nazir said, well, there's people that come into the shop that I don't want them to know my name and address. So I don't know who's coming into the shop, and he was advised about putting the license in a prominent display so everybody could read it. When asked about training, Mr. Nazir seems more concerned about the nitroxide and that he's allowed to sell it. And I say that's not a problem. But when asked about the training and about the licensing failures, he basically said there's no training because I've been dealing with the illness in my family. Speaking to trading standards, seemingly this was told to trading standards in the last inspection a couple of years back. So I don't know what's happening with the family. So carried on. We thought it was more important to deal with the nitroxide and the sword. So we left it at that. And the investigation over that has been carried out by the local officer, and it's still an ongoing incident, ongoing investigation. During the investigation of the serious assault, detectives seized the CCTV equipment or asked for the CCTV. The copy they got just wasn't fit for purpose. So the detective had to go down again and give them equipment, which they took a copy of the footage. It was sent away to specialist CID, police CID, forensic officers who managed to download the footage, but when it was played back, couldn't really see anything on the CCTV. This has hindered the investigation a bit. So again, the condition of the license is to have working CCTV. There's no point in having CCTV if it's not doing its job. So the large swords and the nitroxide is being investigated. Another thing about the nitroxide, I say there was a larger quantity of 615 gram canisters. Normally you see the small silver canisters all over the place where there's just the one pop into a balloon and use. But these big canisters are fairly big, and there's a lot of usage out of them. What was also seized was a quantity of white nozzles that screw into the canisters. And from what I've heard, you don't need these if you're putting them into a cream dispenser. These nozzles are purely used for filling balloons. But I say I'm not an expert in nitroxide and how it's used. But that is the concerns the police. We also received an email from the local college saying that a lot of the students have been coming in with e-cigarettes, vapes, who are underage, which the college had seized, and the students have said they've come from Londis. Speaking to the detective, it seems like this just seems to be an open secret that this is where you go to get nitro oxides. One of the other businesses I can't name actually had somebody come in and dump 2 empty canisters and complains that you can't get nitro oxides from Londis anymore. Also during the visits, there was a quantity of homemade forms, which is giving a sort of declaration of the person who's buying the nitro oxides. On this form, I know it's due diligence, but or attempted due diligence, but there's name and address on it and proof of ID on these forms. When officers seized them and took them and did their investigation, the officer reported back to me that out of the amount of forms that they had sold, that they'd taken during the seizure, 2 of them were known people that the police know that do drugs. The rest of the forms either couldn't be reds or were false names and addresses. Also in the form, there's a place for ID checked. And surely if they're checking ID, they could check the ID and the address that's put in the form and work out. Well, you can't have ID if it's a false address. As I say, a lot of this stuff has come from trading standards, and I'm sure Mr. Mitchell will go into that when he comes up. But that is our concerns about the premises and the severity, and that's why we brought the review.
Thank you very much. Do the panel members have any questions for Ms. Ware?
I don't know whether you're the right person to ask, but with the nitrous oxide canisters, you say they were stored under the counter.
Yes, on the agenda, there's photos of where they're stored in boxes under the counter, and I think there were some found up in the storeroom as well.
Where would you normally expect them to be stored? I mean, if they were being sold for legitimate use.
I have no idea. You'd have to ask the licensee where they normally. I don't know if there's regulations where they should be stored.
Well, that's what I was asking.
Yeah.
Are there any regulations?
I don't know.
Where
Trading standards might be able to answer that question. So,
Very little. I was going to say, your homemade forms that you found, was there any of those filled out with the ID, with the proper specimens of glass?
I haven't examined the forms. It was the investigating officer that's looked at that. But from what she said, some had been filled out, but none of them seems to match up. The 2 of them is known.
Not sufficient.
Yeah.
Is there a proper form available for that purpose?
I don't think so. I don't know. Again,
No, there's not.
no.
Yes.
It's a very. Anybody used to be able to buy nitro oxide now, and now they changed the laws and they've made it a Class C drug under the Drugs Act. I think it's still fairly wide open of what's happening. You know, you can have it, but you can't misuse it. It should only be sold to people for catering purposes or rocketeering, people that do the rockets. And there's some other, again, trading standards are more of faith with the use of it. The same, I'm not called a licensing officer, but yeah, from what I've read, there's only certain things you can buy it for. And, when people are inhaling it, that's when it becomes an offence.
Local shops to sell this. I would have thought a caterer would have got it from a legitimate store, cash and carry or something.
Well, that's what I would have thought, but it seems to be a lot of shops are storing it.
That's a good question for the license
Yeah.
holder in terms of
Yeah.
whether
Any further questions? Does the licence holder have any questions? Mr. Ware? No, thank you. Does the licence holder have any questions?
No, thank you.
Thank you. I will now invite the representation from each responsible authority to present their case. Starting off with Simon Mitchell, who I believe is online.
Good morning, everyone. Good morning, councillors. Thank you for giving me the time to speak to you about this matter. I hope that you've had an opportunity to read through the supporting representations that are shown at Annex H that I submitted ahead of this. I don't propose to go back over those in their entirety, but there are some additional matters that I'd like to speak to you about, and also perhaps address some of the questions that have already arisen this morning. So the decision to support a licence review recommending the revocation of a premises licence is not one that's taken lightly by Oxfordshire trading standards. And in this case, we have to weigh the safety of the local community, particularly children, and the maintenance of a level playing field for all local retailers against the potential implications that may arise for Londis. As you will see from the timeline in my supporting representations, trading standards have an extensive history with this premises concerning complaints about the underage sale of alcohol, e-cigarettes and the supply of nitrous oxide. This includes a failed test purchase in 2022 that was carried out by trading standards, despite an earlier visit to the premises to give advice on how to prevent such sales. On that occasion, we decided to resolve the matter via what we felt were proportionate and lenient means, and attempted to work with the business to bring them into compliance. And the letters that were sent to the conclusion of that investigation are included in my in Annex H. Those were letters to Mr. Mohammed Nazir and Safraz Nazir, who were the two people involved. Mohammed Nazir as the licensee and Safraz Nazir as the person who actually made the sale to our underage volunteer. Now, sadly, the approach that we adopted does not appear to have worked particularly efficiently because, as the representations document, we've had numerous complaints since that time. And those have obviously culminated in the events of April this year. And I refer you to the statement of DC Turner that Mr. Wares has already mentioned, which covers that in more detail. Consequently, we're not left with any other option than to support this review as a means of upholding the licensing objectives, protecting the public and other local traders. Now, I think a lot of what may be discussed and questions that have arisen may revolve around the sale of nitrous oxide, but I don't think that we should lose sight of the other matters of concern here, which are underage sales and a failure to comply with the existing licence condition. When I interviewed the business following the underage sale in 2022, I identified areas where they were not complying with their existing premises conditions, and advice was given on how to rectify that simply and cheaply. And then this May, we found Mr. Wares during his check obviously found widespread issues with non-compliance with the licensing conditions. So the question for the panel to consider carefully, whatever decision is made, is whether they have confidence in the management to implement improvements, prevent further issues. And I hope my representations and what I say today adequately express the reservations I have about this. I believe the panel has had sight of a letter dated the 16th September from Dr. Ghulam Shabir, solicitor. Can I just check that's the case before I continue?
Yes.
Now, that letter states that the business was, and I quote, taking the precautionary measures by getting the buyers to sign the refusals register after documenting their details, end quote. And the form in question is shown in annex in Mr. Wares's application on, I believe, pages 45 and 46 of the agenda. The licensee also claims that he sought advice from trading standards about the sale of nitrous oxide, and I would welcome the opportunity to ask him questions about that advice in due course. However, all I have seen so far is an email to West Berkshire Trading Standards that's included in the licensee's bundle asking for advice, and that email is dated the 23rd of June 2024, which is after nitrous oxide became a Class C drug. So to clarify things, before that it was caught by the Psychoactive Substances Act 2016, and it was illegal to sell it for its psychoactive effects. The misuse of, including it under the Misuse of Drugs Act, meant that it was more tightly controlled in terms of its possession for supply. So before you could possess it, provided that you were not selling it for inhalation and that was known to you. The current guidance is has been, say, tightened up to make supply much more regulated, essentially. Now, that email to West Berkshire Trading Standards was sent after government guidance on this topic was issued, and I quote from the government advice, which is, I'll begin the quote now: "There are still many necessary uses for nitrous oxide in healthcare and other industries, and those with legitimate reason for possessing the substance will be exempt from the ban. For example, it will continue to be lawful for catering purposes and in maternity wards when used as pain relief during labour, as well as for other activities such as use in industry, dentistry or model rocketry. Licenses will not be required to carry nitrous oxide, but individual users will need to demonstrate that they are lawfully in possession of nitrous oxide and not intending to wrongfully inhale it. The maximum sentence for production, supply, importation or exportation of the drug for unlawful purposes has now doubled from 7 to 14 years imprisonment. As is already the case, there is a responsibility on legitimate producers and suppliers of nitrous oxide to not be reckless as to whether someone is buying their product for wrongful inhalation with no legitimate reason. Suppliers who ignore the risk that their customers may be intending to misuse the drug could also be committing an offence." And that's the end of that quote. Now, that quote is taken from a gov.uk post called "Possession of Nitrous Oxide is Now Illegal," and that's dated the 8th of November 2023. There's further government guidance on the gov.uk page, "Nitrous Oxide Ban Guidance," also published on the 8th of November 2023. And I'd like to quote the following paragraph from that. So, quote, "It will be a criminal offence to be found in possession of the drug where its intended use is to be wrongfully inhaled to get high. Where a person is found in possession of nitrous oxide and intends to wrongfully inhale the substance, and or in the cases of importation, exportation, production and supply, knows or is reckless as to whether it is likely that another person will wrongfully inhale it, they will be committing an offence. Wrongful inhalation means inhalation other than for medical or dental purposes, and which is not accidental inhalation of nitrous oxide, which has been released into the atmosphere, such as in industrial processes. Medical, dental and veterinary administration of nitrous oxide, which may involve inhalation, will therefore continue to be lawful, as will other activities such as use in industry or model rocketry. There is a requirement on importers, exporters, producers and suppliers to take appropriate steps to not be reckless to ensure that subsequent users will not inhale the substance recreationally," end quote. Now, these guidance documents can be found using a simple Google search, nitrous oxide UK law, and they are the top 2 results for a search using that phrase as of this morning. I cannot believe that any trading standards employee would fail to advise Mr. Nazir of the responsibilities inherent to a retailer of nitrous oxide. The terms of use document used by Londis, as previously mentioned by Mr. Wares, appears wholly inadequate as a mean of identifying whether the gas is going to be misused. All that's checked is a customer's name and age, and they then sign a notification saying that they will not use the gas for anything other than catering purposes. There are no background checks, verification that someone's employed in that trade, requirements for purchase orders or any other form of documented order, just a name and a signature. And as the tragic events of April 2025 illustrate, the system did not prevent the sale of the gas and alcohol to a group of intoxicated teenagers. It doesn't work, and in my opinion, it could not have worked. And I believe that is an element of recklessness on the part of the licensee. In terms of the panel's question about the storage of nitrous oxide, this was kept at the till point, so it wasn't on open shelves where it could be snatched or otherwise taken, which is good in the same way that you would store spirits or other high value items like medication, coffee, that sort of thing. There's no strict guidance on where things must be displayed and stored, but obviously it's considered to be good due diligence to keep a product like that in a place where it can be easily monitored by staff to prevent, theft or other loss of that kind of material. To go to the other comment by the panel, yes, this is a product that we would normally expect, particularly in these large capacity canisters, to be sold from a more specialised retailer, a catering supply company, someone selling things directly to model making enthusiasts, or a supply contacting the NHS for private dental practice or something like that. That is not to say that it could not be purchased as retail from a local convenience store, but the expectation is there on the retailer to ensure that proportionate due diligence has been taken to make sure that it is not abused. I hope that addresses the questions that have been raised so far. I welcome any other further question from the panel, and I would appreciate the opportunity to ask Mr. Nazir some questions in due course. Unless there's anything further I can assist you with, I will be happy to take questions.
Okay. Thank you, Mr. Mitchell. Do you have any questions?
No.
No, fine, thank you. Okay, do you have any questions?
Yes, just two, if I might. Reference was made to the authorisation form, which I believe appears on page 52. Can I ask whether the County Council produces a template authorisation form for the sale of nitrous oxide?
Well, as I explained in the government guidance, there's no requirement for there's no licensing scheme, so there's no official register that someone can take part on. So anyone selling a product like this, it's because it is a controlled drug now, not a regular product. It's not something that would normally fall under Trading Standards' jurisdiction. Back when it was the Psychoactive Substances Act was in effect, it was a sort of joint jurisdiction with the police, but now it is a Misuse of Drugs Act offence, and it is a matter for the police. So no, we do not have a form that a business could use. As the guidance makes very clear, the onus is on the retailer or wholesaler to ensure that they have taken adequate precautions. So that's not a function for the County Council to do. I say we're not licensing people in the same way that we do for, say, fireworks or petroleum storage or things like that, which do fall under Trading Standards remit, and there are guidance documents and forms like that. This is a controlled drug and should be taken extremely seriously in terms of ensuring that it is sold responsibly. But the council can't be, unfortunately, we can't do bespoke forms for every product. The responsibility does fall on the retailer.
Yeah, I'm conscious that was a very long answer to it. What could have been a yes or no? So I shall ask for the answer for the next question to be a yes or no. Can I just clarify? You agree that it is the right thing to do to store nitrous oxide in locations such as behind the till, so it can't be readily accessed by the public? Is that right?
Yes.
Good. Thank you. Thank you. Does the licensing officer have any questions this time?
I don't. Thank you.
Can I ask Mr. Fletcher to make a presentation this time?
Yeah,
Or do you want to add anything?
So unfortunately, part of my submission when I made my representation didn't make it into the report. So I have hard copies of that, which I can only distribute with agreement of all parties. The only letter I've got is a letter that was sent to the licence holder back in June. So whether you agree for me to distribute that, it's referenced in my submission where it says "see below," so it's sort of whether they kind of wish to see that.
I think that would be useful. Well, Chair, I'm afraid it's all parties, that includes
Yes,
the licence holder, so I haven't seen it. If I haven't seen it, the answer is no. But of course, if I can read it, maybe the answer might be yes. But I need to see it first. My suggestion is that if I'm given a copy, then the hearing is adjourned for a period of time for us to analyse that and take a view.
Do you think it's
So it's a summary of the findings when I did the visit, which are themselves summarised in my submission. So it's not going to be a key piece of information that's going to make a massive influence on the decision. But it's up to you whether you would wish me to present a copy for them to review.
I don't think that is necessary.
That's fine. I say it's only a summary of my findings. Okay. So as the submission in your pack outlines, the representation relates to details of the visit conducted by licensing officers in May 2025, where a number of licensing offences were identified, which raised concerns as to the activities being carried out at the premises. As with any licence or authorisation issued, activities are expected to be carried out in accordance with the legal requirements, and any failure to comply with legal requirements should be taken seriously. Licence holders are expected to ensure that their staff are suitably trained to ensure the legal requirements are complied with, regardless of whether they themselves are personally present. The visit conducted by Vale Whitehorse licensing officers was a week following that conducted by Thames Valley Police, where they themselves identified a number of issues to staff at the premises. However, these same issues were encountered by Vale Whitehorse licensing officers, suggesting that no efforts have been made in the intervening period to rectify the issues that had been pointed out to staff. A letter was sent to the premises licence holder to advise the issues that had been identified and with a request for them to reach out once they've made efforts to sort these issues so that a follow-up visit could be carried out. However, to date, no contact has been made by staff at the premises to confirm these issues have been resolved, which is a disappointing lack of engagement. In respect of nitrous oxide, I'm not going to labour that because it's been discussed. As per the guidance, it's reckless to sell where there's a possibility it may be consumed for psychoactive effects. Given it's a fairly specialist catering and other products, it's debatable whether that would be done in a local convenience store. And certainly based on the evidence before you, there's suggestion that it's been sold with attachments that allow for immediate consumption. There is concern that over several years, issues of illegality have arisen in association with the premises, and it's the view of officers that the premises operation is not in support of the licensing objectives. Advice has been given previously in writing, yet issues have continued and therefore suggesting that lesser measures are insufficient to support the licensing objectives.
Do either of the panel members have any questions?
With regards to postage and information that you identified, there was a meeting in the premises.
Sorry, could you start again? Sorry.
The information to be displayed within the premises,
Yeah.
saying under 25 or verification of age and all that sort of thing.
Mhm.
And you supply that. Was at any time someone decided to have a look at the CCTV if it was up to scratch? In
So-
other words-
Sorry.
Sorry, it's okay. It's just that supplying the posters, that's all immediate, that's fine. And verification really is the CCTV. And it's something they must have. Was there any people looked into that to see if it was actually working at that time?
So I didn't check the CCTV system at the time I visited. It's at the time with one member of staff, it's not, and customers coming in and out, it's a difficult way to go into that. But generally, if a license is issued, typically we'd aim to do a visit soon after it's issued to check compliance. But it remains the license holder's responsibility to ensure that they're complying with the conditions. And where a CCTV system is related, that system's up to scratch.
Any further questions? Does the license holder have any questions?
Yes. I'll be brief. I wanted to assist the committee whether the officer could explain to the committee where in the legislation it says that a person has to be authorised in writing to sell alcohol.
It doesn't say in the legislation how to say it right. It's detailed in my submission.
Yes. You would agree, therefore, that an authorisation can be verbal.
By definition,
Yeah.
if something is not required to be in writing, it can be in other formats.
So that'd be brief. That's it. Thank you.
All right, can I say something at this point? To that? A verbal authorization. Does it seem to be?
I think that's a comment.
I think it was a question rather than.
Okay, Chair, I'm happy to expand on the law in relation to that, as you'd expect me to when you ask me the question that I'm sure that Councillor O'Leary will ask me in a moment.
Thank you. Does the licensing officer have any questions at this stage?
I don't, thank you.
I don't think that any other people making representations, nothing online. So I think we now go to the move to the license holder presenting their case. So thank you. And I don't know how you're going to do this. Is the license holder going to speak or?
Chair, I'm going. I think it's probably best that I deal with most of the matters. If there are things that I need to take instructions on to answer questions, then I'll do that. If there are things that Mr. Nazir needs to say, I'll let him chip in and say things. But I think it's best that I do so. Chair, I'm conscious that we've perhaps been slightly light on introductions. I know I've been before this committee before, and you'll know that I'm a lawyer and I represent the licence holder in this. And licensing is one of the things that I do, as you'll appreciate, having been in front of you before and having had the delight of filling the post of the licensing manager at South Oxfordshire Council when it was a separate entity in true form. But the point here is that Mr. Nazir, to my right, is the director of the new company that now holds the licence for this premises. The company was not the licence holder when all of these issues that are being complained of took place. And bear in mind that those issues took place, you heard cited back to 2022, some significant time ago. There's also a complication in that there are a number of people by the name of Mr. Nazir and also Mr. Mohammed Nazir. This is a different Mr. Nazir that we have. I'm sorry, is there an issue?
No, I'm just confirming that Mr. Sarfraz Navaz is the sole director of the company.
Very good, yes. So that is the position that the licence holder we have before you now is not the same licence holder that was in place before. Also, the designated premises supervisor He is not the same designated premises supervisor. And you'll have heard about what the position is on that. The situation is that when the application was approved to transfer the license to the new license holder, an application with immediate effect, and those words will probably spring to your mind, was made in relation to the DPS. Making an immediate effect application meant that as soon as that application was deposited, Mr. Nazir, to my right, became the DPS. So we have a change of the management, we have a change of the license holder in this particular premises. Chair, members, I'm conscious that the premises is not that far away. Could I just check whether you're familiar with the premises, whether you know the layout of the premises, whether indeed you've been to it?
No, only through photographs.
Just through the photographs.
Yes.
Great. I'm just conscious it's almost on your doorstep, and I know that the premises has a lot of custom from the council offices. I wasn't sure whether you've been there. Again, from the outset, I have to make a point about these proceedings and the way that things are progressing. You will have seen the letter, it's already been referred to from Mr. Shabir, who is a solicitor representing Mr. Nazir on other matters. You will see in that and in the correspondence that the records belonging to the premises in relation to refusals of sales and what have you have been taken by the police. Now, those records have been requested to be returned, indeed, so that we could use them if necessary in this hearing. Those records have not been returned despite requests, and I believe repeated requests. So in some respects, we are faced with an unfair situation that we cannot produce to you some of the evidence that we might have wished to produce if we had had those. I need to make that point from the very outset, that we are prejudiced from the very beginning in this particular hearing. However, it may be that is irrelevant if you agree the position that we take in terms of taking this review forward and what action is taken. But let me deal with the issues that have been raised. First of all, there is a suggestion about vapes being sold from the premises. That is, of course, something which is very much on the horizon with the new vapes and tobacco licensing legislation that will come in and quite clearly deal with that. But Mr. Nazir and the company strongly denies making any sales of vapes to underage or to people who are not entitled to buy such. I'm conscious that isn't the main focus that has been put towards you. What has been put to you is that there has been some heinous crime in that the licensing conditions or the terms of the license have not been complied with. Well, Chair, Councillors, I urge you to look at what the license says in its conditions and take into context what is being alleged. What is being alleged is that there is a terrible, terrible thing in that the summary of the license has not been on display. Actually, when you look at what the evidence is that the license summary has not been on display, in that the license summary has had some tape over it and it's been put in a position which is perhaps difficult to read, so that personal information is not disclosed. In my submissions, that's actually quite a reasonable point, is that the home address of the DPS, if that's what is being obscured, is not disclosed. That is a matter, but that in itself is not a terrible matter. It is also suggested that the CCTV doesn't comply with the conditions. Well, if you look at the terms of the conditions are very poor indeed. There is no requirement, I believe, for it to be operational. It just has to be there. There's no standard that it has to fulfill. There is a CCTV system. It does work, and you've seen and you've heard the evidence that's been given to you that CCTV has been provided to the police. Whether or not it shows what the police wanted to show, because the camera's pointing the right way or not, is another matter. But there is a CCTV. So in my submission, there's nothing in the allegation that there is a breach of the condition in relation to CCTV. The other matter that's suggested, and you've heard the answer that was given about this, is the authorisation to sell alcohol. And I know the question is going to come, so I shall perhaps try and preempt it. There is nothing in the legislation which requires a person to be authorised in writing to sell alcohol. The authorisation comes either through holding a personal licence, or somebody who holds a personal licence authorising someone else to sell alcohol. And that can be as simple as, Fred, you're now authorised to sell alcohol while you're working here. Now, of course, that's not perhaps the best way of doing it, but that is permitted by the law. Now, that situation has actually been addressed already with this company, with this new licence holder, because the company now has, and I believe uses, the forms that have been provided to it, which do give a written authorisation. And so that is something that has been improved beyond the requirements of the law. So to say that the licence holder ignores the law, is flagrantly disregarding it, would be quite wrong if that point was ever made. Furthermore, there is a requirement to have a notice on display. And I've always struggled with why this is required. There's a requirement to have a notice on display to explain who the DPS is and where the licence is. That situation, if it was defective in the past, had been addressed. There is a notice on display. And the point that I make is that that notice goes again one step further to explain who at the premises is authorised to sell alcohol. So an enforcement officer coming to do the job, and I know enforcement officers are really busy, can just look on that notice and can see on the notice who it is that's authorised to sell alcohol. Those things have all been taken care of. Now, there was a suggestion, or it's not disputed, that there was a sword found within the premises. That was, as you'll see from the correspondence and the details that you've been given, something was given to Mr. Nazir by a customer. It has never, to my instructions, been actually scabbarded. It is there, kept out, or it was kept out of the way. And indeed, police officers, I am instructed, knew that that sword was there and had visited previously and seen it, but had done nothing about it. I think the words were that "don't tell us anything about it" was
we don't want to know.
Yeah, was perhaps the thing that was said. It of course was wrong. It shouldn't have been there. It's not there anymore. But so that particular matter has been dealt with. The fundamental point, though, that seems to be the cause for the review is this selling of nitrous oxide. That seems to be fundamental to the reason, in my submission, for the review being called. But why does this premises sell nitrous oxide? You might ask. Because it's entitled to do so is the glib answer, but because it does so for businesses and other individuals who have a legitimate purpose for buying nitrous oxide in the area. Now, one might say, well, if you're selling nitrous oxide, then presumably you must sell other things that might be ancillary to that, such as, for example, a creamer to put the nitrous oxide in to use for catering purposes. And indeed, that's very much the case. And if you look on page 8 of the supplementary information that we provided, you can see a gold whipped creamer box on display on the shelves, available for sale to customers. So that is the point. That this is not just it's not just at all. It is a case that there is a legitimate expectation that customers will use it for authorised purposes. And you will have seen the evidence, the emails that have been sent backwards and forwards, seeking advice from training centres. Admittedly, it was the wrong authority, and perhaps it should have gone to Oxfordshire, but the West Berkshire was inquired on to give some advice on that. And in the absence of any authorization form, and you've heard from trading standards that there was no authorization form, the premises have taken a responsible step, not a reckless step, but a responsible step to design their own form for potential customers. That's not the actions of a premises that's being reckless. To have a policy which was seized by the inspectors when they came to visit, the police when they came to visit, that is not the act of a reckless business. It's the act of a business that is trying to comply with what has already been explained as a change in the law, and the comment that I'm grateful Mr. Ware's making is wide open as to what happens with sales. The position is not as clear as it perhaps should be. Perhaps there should be, as there will be with vapes and other tobacco products, some sort of licensing regime, but we're not there at the moment. The position is still somewhat unclear. I agree that there is guidance, but the position is still somewhat unclear. But this is a premises that put things into place to try and comply with the legislation that was forced. So those are the main points that I want to make. Our suggestion to the committee, and I'll deal with these in submissions at the end as well, is that actually the appropriate way of dealing with this is to impose a set of robust conditions on the licence, to recognise the steps that have been made, and not to take any other action, regulatory action in terms of the licence. Chair, you've had the evidence put before you about what's taken place. You've heard from me on this. I'm more than happy to answer any questions that I can, given that my questions cannot be answered in relation to the conduct of others who may have been involved in this premises.
Thank you for that presentation. Do panel members firstly have any questions?
You mentioned, and you're quite dismissive of the sign that was up on the shelf.
Yes.
Behind. It's not readily seen at all. And yes, if you've gone up and brought it down and have a look at it, but to suggest it was there,
yes,
it was meaningless to be there, to be honest, because it wasn't doing its job. Simple as that.
Yeah. And that position has been correct. That situation.
Yeah. It's things that been told in the legislation to say how you're supposed to deal with this thing. People underage, and we quite rightly point out maybe that someone who sells alcohol is okay, but if you're deemed to be under the influence or underage, that's all there.
Yes, no, I don't disagree with you. Those who are working in the premises are under a duty, a personal duty, as well as part of the business, to make sure that they don't sell alcohol to those who are underage or drunk. Absolutely, I don't disagree with that at all.
When it comes to the CCTV, there's a guy who said that there is CCTV, yes, it is working, what have you. But be blunt, it's useless. It's CCTV in name only.
Well, Jack, I'm conscious that that's a comment.
Yes.
I'm conscious that it's not based on any evidence you've heard. All you've had is that the CCTV didn't show anything. Now, that could be because the camera was pointing in the wrong direction, but what was wanted. It could mean that the images are not clear. We don't know. That evidence hasn't been given. The opportunity was given for it. That opportunity has been passed. All we know is that CCTV did not show what the police wanted it to show.
Okay, thank you.
Thank you.
Councillor Shaw, do you have any questions?
I understand that at some stage robbery took place at this premises. Shouldn't the CCTV have been checked then by the
By the proprietor at the time,
Yes.
and by the police, I think I would probably agree with you.
And I mean, if I had been the proprietor, I would want to make sure that the CCTV was absolutely up to scratch.
Yes,
from
good.
that
That's the
point.
construction. Wasn't working. Private court. Prison.
There we go.
Yeah.
So the CCTV was working. I don't know if you heard that. The individual was caught. He was in prison for 5 years. The CCTV worked.
Fine. And then it wasn't checked after that to make sure that it continued to work.
By enforcement, presumably not. But to the best of our knowledge, the CCTV system has always worked. It hasn't been a case of cameras up on the wall or on the ceiling which aren't recording. The system is recording, has been recording.
Thank you. I think just one question. We had evidence that there has been underage buying of alcohol at this premises, and we have evidence also that it has sold nitrous oxide, which has been used in an illegal fashion. You dispute either of those claims?
Well, in terms of what's happened, I cannot tell you whether there has been such a sale. The evidence it suggests, and I'm conscious there is some hearsay evidence because in relation to the girl, the evidence is given by her father, that there was a sale. If it happened, absolutely, it was wrong. That was done under the watch of the previous licence holder. And I've seen some evidence which suggests that some of the records have been wrongly completed on the check sheets. We cannot answer to that because we don't have them, so I don't know. But suffice to say, this is not a premises that condones such behaviour. If it is made clear that there was a particular individual who made that sale, then I have no doubt that very strong disciplinary action will be taken against them. And of course, if we could identify who that was, then something that has been done with other licenses is those individuals are excluded from doing any business. I dealt with an application just last year, no, actually earlier this year, where an individual was excluded from working in the premises. If we could identify who it was that made that sale, if it took place, then we could take that action. But we are in a disadvantaged position, not knowing who it was that made that sale.
Mr. Ware, do you have any questions for the applicant? But the license holder?
If I can make a comment about the CCTV, just to clarify that.
I'm sorry, but it's the time for comments has passed.
Okay.
Well, that it maybe if you would like to pick it up in your final submission.
Yes. It's difficult on you disputing that any evidence was presented, but there is some evidence that the CCTV footage was not suitable. So it's just disputing some of the comments you've made. So it's not a new comment.
So do you guys
No,
have any further questions? Right. That's it. Sorry.
Actually, I've still got one question.
Oh, sorry.
To ask, if that's all right.
Yes, okay. Sorry.
What is being done about training now, as opposed to
Yes.
last year or the year before?
Yes, indeed. So you'll see at the beginning of the additional pack, there are 2 training certificates, which are in relation to age verification. Those were done, as you can see, 9th of the 4th, 25, and the 17th and 6th, 25. The other step that is being taken is that staff have been offered, I believe, I know staff have been offered access to what is the Napoleon's training. Now, you've probably heard me talk about Napoleon's training. It's a training package that's provided for premises such as this by a group of training standards authorities. They've got together and produced this training package. That is something that is available to all staff, and staff will be expected to complete that so that they are fully up to date with the law on age-restricted products and other matters, which is, as I say, a course provided for by a training standards group conglomerate.
I mean, is there provision for ongoing training?
Yeah.
And how many staff are there who have been trained?
Two staff at the premises.
You've got a question? No.
So could I just deal with that a bit further? I mean, it probably is helpful to deal with it at this point. You'll see that we have proposed a number of conditions, and you'll see that condition 1 that we suggest is much more comprehensive in terms of its scope, and perhaps deals with your concern about what would happen with playing going forward.
So, do you have any further questions?
Yeah, please, a couple of questions. So the premises license was first issued in 2010 to a Mr. Mohammed Dildar Nazir. Now, I appreciate, obviously, that Mr. Mohammed Sarfraz Nazir has only had any legal responsibility for the business for the past month, but the letter from Mr. Shabir's solicitor refers to Mr. Nazir being robbed in 2014. Can you just tell me how you've been involved in the business over the past years?
Since 2011, I've been working there 2-3 days a week. Since June, working there 7 days a week now. I'm basically doing everything, ordering, filling, everything.
Okay, thank you very much. And in relation to the pack that was submitted, I'm a little bit unclear when referring to the additional ancillary stuff that's sold with the nitrous oxide. You've got a photograph of the display. Can you tell me what that big black box is in that
That's the
photograph?
machine that the customers use for the cylinder.
Right.
That's
For the
machine, yeah, for keeping use.
Yeah, and you put something else in there as well?
No, that's it.
Oh, right. Okay. And when was that photograph taken?
Oh, really?
There seem to be any dates on any of
No, there's no date on it. It was taken relatively recently.
Right, thank you. Thank you.
Sorry, like when?
Within the last 2 months, I would think.
Okay.
I've got no further questions.
Right, thank you. I think that concludes the representation stage of this panel. Now,
Would it be possible for me to ask some
sorry.
questions?
Oh, sorry, yeah,
And yeah.
being online, I've forgotten that. You're sorry about that.
Sorry, that's quite attending remotely, I suppose. Yes, I have a few questions. So the company Londis Marciano Limited was incorporated on the 9th of April 2025, which is the same day as the police officers attended the premises seeking evidence related to the sexual assault. Would you care to comment on the timing of this and the reasons for the license being transferred at this, or seeking to be transferred at this point?
So there was already an intention, because of ill health within the business, to transfer the license, and purely coincidental that it happened on that same day. It would be remarkable if somebody formed a company on the same day that this incident occurred.
Right, but the incident involving the young woman, I believe, happened on the night of the 7th of April. And earlier on, you said that you couldn't identify the person who made the sale to initiate internal disciplinary matters. But then you've said that there are only 2 employees. What is the issue in identifying who was working that night?
So we don't know which one of the employees it was. That's the simple answer. Without the record sheets, we can't identify who that was.
I'm sorry, without the
log sheet.
Okay, and why does you not have possession of the log sheet?
I think we've already dealt with that, but it's been seized by the police, and they haven't been returned despite requests.
No, I'm sorry, but okay, but why is there no staff rota, or so you know who to pay for working that evening?
not sure that that would actually assist us. What we're interested in is who actually made that sale.
A till login, perhaps? Any records there as to who was logged into the till that evening?
I think that's enforcing a greater expectation on a small business with 2 employees than actually exists.
I worked at a convenience store when I was 18. I had a till login. Always did to everyone else who worked there. It's just a way to make sure that the tills are even at the end of the night.
Is there an answer, I suppose? Is there a till login?
No,
Right.
it's normal kills.
Right. So the answer is you've got, and let me get this right. You've got no idea who was working there. You've got no idea who was logged onto the till, and no idea who was serving customers or carrying out transactions for that entire day.
But the answer to the question that I can give is we do not know who it was that made that sale.
Okay.
Very well. I've had a look at the new proposed licensing conditions. There's a substantial focus on the business making changes to allow the continued sale of nitrous oxide. Can I ask how many nitrous oxide cylinders the business currently sells per week, approximately?
I think about 3-4.
3 or 4. Okay. And what percentage of the store's turnover does that represent?
I think that's rather a difficult one to try and calculate on the hoof.
Okay, let me simplify it. How much profit is made on each cylinder that is sold?
It's about £3.50.
So if it's 4 at maximum, we're talking about £14. Is that correct?
Around about.
So how much what are your daily sales? Do you have an idea?
Not only one, I know.
£1,000?
Yeah, just under.
Just under.
Yeah.
So £1,000, just under £1,000 a day. So let's say £6,000 per week, and £14 of profit from that is nitrous oxide sales. Is that correct?
Yeah.
Okay. So if the sale of nitrous oxide represents such a small part of the business's trade, why were conditions not submitted where the business simply says, we'll stop selling this and remove the risk to the community of the gas being abused and yourself from the legal risk associated with supplying it?
I was soon coming.
Yeah, but presumably he's asking why he didn't reach the swap something.
There's no reason.
Yeah.
Was it?
I think the purpose behind the question is obviously clear to me. But the point is that this is a commercial decision that's been made. It is one of a number of products that are being sold to businesses and individuals. The decision was that they wanted to continue to sell and not to offer that for legitimate purposes. That's the simple answer.
Okay. So turning again to the photographs that you mentioned that have been submitted as part of the licensees bundle, there is a single whipped cream dispenser shown on the shelf. Can I ask, is that the extent of the shop's commitment to claim to be a catering supply company?
No.
Okay, very well. I'll expand on that. What other products or stock do you have that would fulfill the purpose of using those nitrous oxide bottles?
Anything else that uses nitrous?
No, that's what
Yeah, that's the only product that's sold in the premises that uses those bottles.
Okay, and furthermore, can I ask, how do the nozzles that were found with the canisters of gas on 22nd of May fit into that device?
They've been taken off separately, so they're not this small. They're the box.
I'm sorry, I didn't quite hear that. I'm totally on
I think
headphones.
we've got a fire.
We've got
It's
fire
not-
alarm, so-
Yeah, I just got that.
They're not given with the cylinder, so they're separate, taken away.
Okay. Okay, so I'll move on. So in the licensing holders bundle, there's a section of correspondence from what appears to be Mr. Mohammed Nazir with an email address of msnazir, Nazir with 2 Zs at hotmail.com, and an email address for I believe it may be and perhaps you can clarify this, your email address, Mr. Safraz Nazir, which is again, saf00 at hotmail.com. I read out these email addresses because they're already in the documents that have been submitted, where they say that they've contacted agencies to seek advice about the sale of nitrous oxide. However, the responses received, if any, haven't been provided. Can you explain why that's the case?
Chair, that's a decision that we've made about how we want to present our case.
Right. Okay. So further on that, the licensee appears to have contacted the Home Office and West Berkshire Trading Standards. If he sought advice concerning nitrous oxide, why didn't he contact his local trading standard service?
So the answer to that is that there was a contact with Oxfordshire, but there was no response to that inquiry.
Okay, I've checked our records and with all of the members of our triage team, and we have
that's giving evidence.
Very well. And then I would just ask, is the reason why the request was not made to Oxfordshire Trading Standards because anyone who received it would inevitably check our records, discover the history of complaints that are linked to the premises as detailed in my representations, and issue advices that emphasises the due diligence required for retailers selling this product?
Chair, my answer to the question on my instructions is the same. An inquiry was made of Oxfordshire County Council. It cannot be said that there was no inquiry because the time for that evidence is gone. An inquiry was made on the instructions that I've been given. There was no response to it, so I cannot answer that question.
Okay.
Very well. Thank you. That's the end of my questions. Thank you very much.
Right. Thank you. So that does include the chair. So
No, we've got Mr. Fletcher.
Oh, apologies. Yes.
Am I correct in saying that you mentioned if you'd identified a member of staff involved in an underage sale, they could be excluded from working at the store? Is that correct that you said?
Yes.
Does that not include Mr. Safraz Nazir when you failed a test purchase in 2022? Why was he not excluded from working at the store?
So he was not involved in that. Sorry, he was. Let me just go back to the point that you're trying to make. If there is a position where somebody is concerned of being a risk to the public, then the licensing committee can add on a condition, which was my point, that person be excluded from trading at the premises. I can't answer the question about why action was not taken at that particular time to exclude. Maybe that there were other reasons why that happened by the license holder at the time. That's a question for the license holder at the time.
And Mr. Safraz Nazir has been involved with the premises for a long time. Is there a reason some of the measures that have been recently adopted weren't adopted earlier?
But simply he wasn't the license holder.
Surely as a member of staff you're still...
He can suggest things, but it is not his decision to implement changes to the way that the business is run.
Very well. Thank you.
Thank you. Sorry, are there any further questions? In that case, yes, we will then conclude that presentation stage and we'll now move into the final submission stage. And each party, if they wish to summarise their view before we go into close session to make a decision, and that I might say summarise at this stage. So would the representative from Trading Standards like to make a concluding statement?
I'm still with us.
Yes, I am. Sorry. I just think that I would like to stress that we've tried to engage with this business. We've tried to help them improve. We've shown them where they were not complying and how to fix it. And we've adopted a lenient approach when we had the previous offence involving the undirected sale. We felt at that time that if the system that was required by the existing premises licensing was properly implemented by the business and with guidance and a reminder they needed to do this, and that would be adequate. The problem is that has not happened, and our confidence in the implementation of any system, no matter how robust the conditions may be suggested to be, is unlikely, and we therefore don't have confidence in this business being able to implement the conditions even as they stand now. So complicating matters with further ones concerning nitrous oxide and due diligence checks for the sake of £14 seems like an unnecessary burden on the business, given their benefits. As I say, it's more eloquently put in my supporting representations, so I would kindly refer the panel to those. But thank you very much for giving me the opportunity for that.
Thank you. Mr. Fletcher, do you want to make any further comments?
I'm not sure I can add anything to what I said.
So with the licence holder, would you like to make a concluding statement? Then
Mr. Ware.
Oh, Mr. Ware, sorry, yes.
Yes. Yeah, just going back to what Mr. Payne said about the licensing breaches. Yes, the CCTV was working, and it's not really the licensing conditions that we're here about today. Normally we deal, as a licensing officer, I deal with licensing breaches. If there are any, it's normally be words of advice or a warning letter. The big concerns the Thames Valley Police had was the sale of nitroxide to people to misuse, and the fact that a young girl who was intoxicated was sold alcohol and nitroxide on several occasions that night. And that now there's been a bit of an argument about who was on duty that night, and I think CCTV would play a big part in either giving the police evidence or defending the licensee. Now, what I was going to say earlier, and this has to do with summing up, is Detective Turner, DC Turner, said that they received the DVD from the premises and it appeared to be corrupt. They've sent it off to Thames Valley Police Specialist Visual Units. The unit managed to format the footage, but the CCTV obtained was not of any use. The footage was completely dark. Nothing else had been seen at all. So it's either the DVD was corrupt or the system wasn't recording right. So it's not a case of whether the cameras are pointing in the wrong directions. However, if that had been working, we would know who served the girl. We would have known the condition the girl was in and how many sales she did. And that wasn't there. And this is the severity. It's not the licensing breaches, if there were any. It's the severity that a young girl went in several times, one of the time being really intoxicated. She could hardly stand and was sold alcohol, liquor and nitroxide. Now, you can't blame the shop what happened in the park, but, you know, both the suspect and the victim have told the detective that they purchased these goods from the shop. That's our concerns.
Okay, thank you. The licence holder would like to make a concluding statement.
I'll be as brief as I possibly can, but I also need to take you to your statements of licensing policy, the section 182 guidance, and some other case law, which perhaps should have been quoted in the officer's report, but but was not. Let me deal with that particular point first, because there is a principle which stems across or runs across all enforcement proceedings about the approach that should be taken to enforcement. And the case that I'll refer to, I'm sure I must have referred to it before, is the case of the Crown and Secretary of State for Health ex parte East Side Cheese, which is from 1999, 3 CMR 123, if you want the reference. The court there held that where there's a choice between several appropriate measures, recourse must be had to the least onerous, and the disadvantages caused must not be disproportionate to the aims pursued. So it's a balancing act, but balancing with the least onerous action that's required to resolve the ill, if I can put it that way, that's been alleged here. Now, the ill that's been alleged here is the sale of nitrous oxide, and one occasion of a failed test purchase. That is what is being alleged. We went from a widespread failure to comply with the licence conditions to the quote that I just heard, which was the licensing breaches, if there were anything. Well, in my submission, the licensing breaches, which essentially extend purely to the display of the summary of the licence, it was there, but perhaps not in the best position, has been corrected. So that particular thing has been dealt with. And this is an application in relation to a licence to sell alcohol. This is what this is about. This is not about selling nitrox. It's not nitrox. That's diving. Nitrous oxide. This is about that. That you've heard from the police. This pretty much stems from the incident involving the girl who took nitrous oxide, had alcohol, excessive alcohol consumption, and then we've heard what happened. But this is about sale of alcohol. So what would happen if you decided today to revoke the license? Would the premises still be able to sell nitrous oxide? Well, the answer to that is yes, it would. It would still be able to do that. This doesn't create any resolution to the main and central point that's being brought to you today. What would have an impact is to impose different conditions on the license. And if you look through the license as it stands at the moment, I would love to drive a horse and carriage through many of the conditions that have been phrased. And that's not criticism of anybody in particular, it's just what's there. It's an older license, it needs to be brought up to date. By putting conditions on the license, it gives you an option with conditions that we propose to control sale of nitrous oxide in premises. It enables you to, with the agreement of the license holder, bring in some regulation that's not there. It brings in a greater degree of control. We've heard from the county council that they don't have any forms that they can use and give or suggest for a license holder to use to sell nitrous oxide. But what you have is a policy from the company. You have a set of forms. You have a very valiant attempt, if I can put it in those terms, to try and comply with the law. Now, those are not the signs of a company that is reckless, to use the words that were bandied around before, which is the sign of a company that wants to show the licensing committee that for those licensable activities in which it has been authorised, it is able to run a tight ship, it is able to control the way the premises runs, it is able to provide, in terms of the CCTV condition, good quality CCTV to the police. And the suggestion that the CCTV system is inadequate is rather blown out of the water by the point that I have taken instructions on about somebody robbing the premises a time ago, and that CCTV being provided to the police, that individual now spending 5 years in prison. the CCTV system at that time worked. It can be improved on, it will be improved on. Now, since this review occurred and since the licence was transferred, there have been steps you've heard that have been taken to improve the premises. You've got the photographs, you've got copies of the images which show under 25 or challenge 25 scheme being used. Page 4, 5 and 6 quite clearly show at the entrance and at the till challenge 25 being put in place. That is not something that there is any current allegation over, that people are being sold if they're under 25. So that is what I say to you, is that it is a proportionate response. And that's really echoed in 1120 of the Secretary of State's guidance. In deciding which of these powers to invoke, it is expected that licensing authorities should go as far as possible to seek to establish the cause or causes of the concerns that the representations identify. Well, those have been identified. Action has been taken. You can deal with it by means of imposing conditions. Now, it may come to you that actually what is also required is that the licence should be suspended. Well, let me deal with what the Secretary of State's guidance says. So it talks about promoting licensing objectives or preventing illegal working at 1123. So, for instance, a licence could be suspended for a weekend as a means of deterring the licence holder from allowing the problems that gave rise to the review to happen again. Any longer than that, I would suggest, is a punitive action, unless it is requiring something to be done within the period of suspension. So what we say in this is that the work having been done, the measures having been taken, the appropriate way of dealing with this is to impose conditions on the licence, not to suspend it, not to revoke it. We say that those would be actions which are disproportionate and therefore unlawful. So we ask that you deal with this review by attaching the conditions that we've provided to you in the report. We ask that you have regards to the actions that have been taken by the licence holder. And great.
Thank you. And the licensing officer is concluding remarks, please.
Yes, so now that obviously you've had a chance to read the report before this hearing, you had certain sections of it explained to you by various parties here, and you've heard submissions by all parties. Therefore, in relation to the application for the review, which was recommended to revoke the licence, you obviously have to make a decision now whether to take no further action, to modify the conditions of the licence, and you've obviously been supplied with some model suggested conditions by the applicant's solicitor. And also there are some draft conditions that the council promotes that are available on our public website. It's probably right that if we issued this licence today, they would have not, the conditions would not have been worded in the fashion that they were back in 2010. It does say that you have the capability to exclude a licensable activity, but as the only licensable activity is the sale of alcohol, that means the licence would have no effect. Remove the designated premises supervisor, suspend the licence, or revoke the licence. Mr. Payne, and there's something that referred to parts of the policy and the Secretary of State's guidance. We've heard a lot about nitrous oxide, so that there are some other paragraphs included in the report, policy 4.1, 511, 719, 15.1, and then the Secretary of State's guidance, and also 1124, 1126 through to 1128. that may be of relevance to you.
Thank you. Please can I invite all the relevant parties to state that they've had a fair opportunity to put their respective causes to the panel.
Chair, I've made the point about the unfairness of not having the records already.
You made that point, yes. Yeah. Everybody else happy. In that case, we'll now make our decision, and this will be done privately with only members, the Democratic Services Officer and the Legal Officer present. If the panel intends to clarify any point, they may call all the attendees back into the meeting. During this time, parties are asked to wait in the reception area, and they will be collected and brought to the room when the decision is ready to be delivered. If any attendee is unable to be contacted, the panel will, after reasonable attempts have been made, read the decision out and send an email to any absent party with the decision.
Chair Greve, I'm also mindful of the time approaching 12 o'clock. I wonder whether there would be an indication you could give about a return time. So, for instance, not before 1 o'clock.
I would very much doubt that it will be for 1 o'clock, but
I'm just conscious that perhaps might be other things that need to be done. Certainly on my part, if we were able to say not before 1 o'clock, because I'm conscious you'll probably want lunch as well.
But I think not before 1 o'clock would be reasonable.
That would be very helpful indeed.
Yes, if we could stop the broadcast.
Bertie, if you can stop the broadcast and come back after 1, and we'll be ready sometime after that to restart. Thank you.
Right. Yes, as I say, just a couple of points of clarification. Tried himself as Mr. Habit Nazir. This man was asked if he was a designated premises supervisor. He stated that he was not. Can you clarify that?
So this is page 24, you say?
Page
Page
24.
24 of the agenda, yeah. We've obviously got a couple of both Nazirs are Mr. Mohammed.
Okay.
I don't know if I can help here because I've just never
Yes.
asked the question. But yes, I did ask the question to yourself,
Yeah.
and he said he wasn't. I thought it was his brother, Asrar. That's
Yeah.
the DPS.
Oh, right. Okay, so it wasn't you.
It wasn't me,
no. No. Okay, that's fine.
Not the designated premises supervisor, but that is that you, the person.
I did come in the store, yeah.
Yes, it was. It was.
Yes.
So the designated premises supervisor at that time wasn't there at all then?
No.
Yes. Okay, I think that clarifies that. The other question was, it says that you hold a personal license with Oxford City, a personnel license with Oxford City Council. Is that correct?
Correct.
Can you tell us how long you've had that for?
I haven't got the right dates on me, no.
For several years, anyway.
Yeah, probably.
Okay, I think that's the question to answer.
Yeah, roughly.
Maybe about 3-4 years.
Okay, any further questions? No, I think that's fine, yeah.
Thank you.
That's just what we're talking about, just a couple of points of clarification. Thank you.
Bertie, would you mind stopping the broadcast again, please, and we'll be back shortly?
Thank you everybody for returning. This panel considered the options available and decided that it was appropriate and proportionate to revoke the premises licence. Full reasons for this decision will be provided in the decision notice, which will be expected within 5 days and will be sent via email. Any party may appeal against the panel's decision under Section 5 of the Act. Any appeal must be to the Magistrates' Court within 21 days or receipt of the decision notice. This has to be made in the correct manner, accompanied by the required fee. I think that's everything. So I think I can now close the meeting at 13:50.
Bertie, can you stop the broadcast, please?